We're joined by legal practitioner Kudus Alalafia. Hello, Kudus. Thank you for joining us at this time.
Yeah, hello, good afternoon. Thank you very much for having me on this program.
All right, Kudus. Now, the Court of Appeal ruled that the Federal High Court didn't have the right to handle this case. Why is it important that the Electoral Act only applies to federal elections and not local government elections?
All right, thank you very much. You know, the duty of the courts, of all court of superior record, is to look at the intendment of the draftman. In their wisdom, it was their decision that the local government election is not covered by all the proviso, by all the sections of the Electoral Act. And if you look at it properly, you will see that from the beginning to the end of the Electoral Act, reading the entire provision in together, it appeared, but of course there is now a judgment of the Court of Appeal, so to say, saying that it doesn't apply to the local government. Well, that is the law as we speak. It appeared, the Electoral Act seems that it doesn't also apply to local government. And whether or not we have another opinion about it as I speak is a matter for the Supreme Court to decide. Like we used to say in the legal parlance, it is not yet decided in its finality, perhaps until...
Hello, Kudus?
Yes, hello, sorry.
Yes, we can hear you now. Yes, you froze for a bit. Please go ahead.
Yeah, no, thank you very much. So I said until the Supreme Court, until it is decided in its finality by the apex courts, which is the Supreme Court of Nigeria. Well, that's still the law as we speak, that the Electoral Act does not apply to the local government election.
Okay, but the court allowed INEC to release the voters registered to RSEC. Now, what role does INEC play in local government elections, and should RSEC, that's the Rivers Electoral Commission, have more control over its own elections? Hello, Kudus, can you hear me?
Agree. Yeah, sorry. Can you hear me now?
Yeah, please go ahead.
Can you hear me? That ordinarily, the Rivers State Electoral Commission should have outright power, absolute power, control over the conduct of the election.
So you're saying that you agree that it should be autonomous?
Yes, it should be autonomous. I agree. Except and until the Electoral Act is amended to now bring in the INEC overseeing exclusively the local government elections. So until it is not, except it is made expressly stated, then of course let each state be in, let them have some sign of independence with respect to the conduct of election in their respective states.
Okay. Now, also, the Federal High Court said that the Rivers State Electoral Commission broke the law by not giving the 90-day notice before setting the election date. Now, why is this notice required, and can there be, exceptions in special situations?
You see, when you look at it properly, from the jurisprudence or the philosophy behind the issue of notice, in essence, it is to make sure that everybody that is meant to participate either directly or indirectly in such an event is given adequate notice. Now, the law has specified the number of days which, in the presumption of the law, it deems fit to be an adequate notice, and anything falls short of that, of course, the law will take its course. The law will say, no, there is no adequate notice. So it's just a way of saying, following the law stricto sensu. Now, you see, when it comes to issue, that's coming back to the issue of exception. When it comes to issue of the electoral process in Nigeria, it is very strict. In law, we say it is sui generis. It is very special. So if you look at it properly, the issue of exceptions, most often than not, even though it may be allowed in some instances, may be creating, depending on the circumstances. But, you know, the draftsman of the Electoral Act and all the electoral laws that we have in Nigeria is of the view that election is for a period of time. And that is predicated upon the fact that, of course, there is time for politics and there is time for governance. So you do not allow the time of politicking to enter into the period of governance. That is why the law on electoral process is a bit rigid, making sure that everybody expected to participate in an election restrict themselves to that period without necessarily straying to a period of governance. So that is my own opinion on that. Thank you.
Now speaking of everyone expected to participate in the election, the High Court, that's the Federal High Court, also stopped security agencies from helping with the election, but the Court of Appeal overturned this. Now, from a legal standpoint, what is the proper role of security agencies in local elections?
Yeah, thank you very much. Even at this juncture, it is now proper for me as a person to even let me say, constructively criticize the judgment of the Federal High Court, stopping the Nigerian police from performing their statutory duties. You see, the issue of security is not even a secondary law, it is primary. The provision of the Constitution, if I'm not mistaken, either Section 13 or 14 of the Constitution says the primary function of the states shall be the welfare and security of the people. So I do not think, in my humble opinion, that the Federal High Court would have been right. And thankfully, the Court of Appeal has upturned that judgment to say, no, it was not properly, that judgment was given in error. Because come what may, there is no period at which our law, particularly our courts, should say that security agencies should stop to provide adequate care, security for the people. Now, of course, thankfully, I'm on the air. See, I know that lawyers too have a role to play in this, so that we do not usually criticize the court all the time. You see, the court usually will pronounce based on what the lawyers of a particular party has placed before it. Then the other party, that's the opposing party, has a duty to also constructively oppose whatever a party is saying. So where a party has brought a fact before the courts, and the other party is not really doing what it ought to do, or perhaps they have done what they need to do, but it's not enough. But it is enough, but they have not placed it in the proper manner they ought to place it before the courts. Of course, you know, like we used to say in law, the judge is the one on trial. Both parties know the truth. So it is the judge that is left to find who is right and who is wrong. And the judge cannot. Of course, judges will not leave their chambers, will not leave their seat in search of evidence. It is whatever that is placed before them. So the duty, I will implore lawyers at this juncture, the duty of a lawyer is to make sure that regardless of the interest of clients, let us always do justice to every case. So whatever you are taking to court, whatever you are placing before the court, place it properly in such a manner that whatever the judge will give judgment on will not be made in error. Okay. That is why we do not, in law, we do not say, we do not usually say courts make mistakes. We will say courts has made an error. Okay. Error as to facts or error as to law. So both, if the fact is not well placed, of course, the law will be misapplied. And that is, with my own view, that's exactly what happened at the Federal High Court. Thank you very much.
All right. Well, thank you so much, Kudus, for taking time to speak to us on this.